Get ready for the dictation. Start. These proceedings under Article 226 of the Constitution of India have ostensibly been instituted in public interest, challenging paragraphs 3 of an order issued on 19th September 1989 by the Election Commission of India, whereby it has been observed that Bharatiya Janata Party shall be recognized as a national party, for which symbol lotus shall be reserved for it in terms of the provisions contained in subparagraph 2 of paragraph 7 of the Election Symbols Reservation and Allotment Second Amendment Order 1989. Similar prayer has been made challenging paragraph 3 of another order dated 23rd September 1989 issued by the Election Commission, whereby it has been observed that Indian National Congress shall be a national party, for which symbol hand shall be reserved. Heard Sri Sesmani Nath Tripathi, petitioner in person, and Sri Vijay Vikram Singh, learned counsel representing the Election Commission. At the outset, we may observe that though this petition has purportedly been filed in public interest, however, from the pleadings available on record, it can very well be inferred that the petitioner has attempted to espouse a personal cause as well. In this regard, it is noted that in paragraph 6 of the petition, it has been stated that the petitioner is a primary member of Samajwadi Party in UP, which is a registered political party under Section 29A of the Representation of People Act 1951 and plea of discrimination in issuance of letters of registration under Section 29A of the Act has been raised by stating that paragraph 3 in the impugned orders dated 19th September 1989 and 23rd September 1989 issued by the Election Commission in respect of two political parties, namely Bharatiya Janata Party and Indian National Congress, it has been provided that these parties shall be national parties and their election symbols shall also be reserved. However, similar provision is missing in the registration letter issued in respect of Samajwadi Party on 21st May 1993. Thus, a cause on behalf of the Samajwadi Party has also been attempted to be pleaded in this writ petition. In the same breath, however, the petitioner also states in the writ petition that he does not have any personal or private interest in this writ petition in any manner whatsoever, and that the petition has been filed in public interest, and also that the entire cost of litigation is being borne by the petitioner himself. The petitioner has also stated that he is a public spirited person and that the matter raised herein carries immense importance. As such, he has filed this petition. In paragraph 4 of the writ petition, it has also been averred by the petitioner that the result of this litigation will not lead to any undue gain to himself or to anyone associated with him, or any undue loss to any one body of persons or the state, though the petitioner admittedly is a member of another political party, namely Samajwadi Party. The writ petition also, in our considered opinion, suffers from non-joinder of necessary parties. In this regard, it is noticeable that though it has been prayed in the writ petition that paragraph 3 of the letters of recognition dated 19th September 1989 and 23rd September 1989 may be quashed and struck down. However, the political parties which are likely to be affected in case the prayer made in this petition is granted have not been impleted as respondents. As noticed above, letters of registration issued by the Election Commission way back in the year 1989 are now being challenged after a lapse of about 32 years, offering an explanation that in case of violation of fundamental rights conferred on the citizenry of this country in Part 3rd of the Constitution of India, delay is not material. Further explanation which has been sought to be given is that the impugned letters of registration have been challenged as the petitioner received reply to a query made by him under the Right to Information Act from the Election Commission by its letter dated 12/5/2021, enclosing therewith the impugned letters of registration in response to his application dated 15/4/2021. The said reply, it has been stated, was received by the petitioner on 27/10/2021. The explanation offered for such inordinate delay in instituting this petition, though is not satisfactory. However, we are entertaining the petition for the reasons given hereinafter. Having observed as above, we have nonetheless entertained this writ petition and processed to decide the same as an important issue has been raised in the petition pertaining to scope and ambit of Section 29A of the Act, and also the powers and jurisdiction of Election Commission under Article 3 to 4 of the Constitution of India. It has been argued by the petitioner that the letters of registration dated 19th September 1989 and 23rd September 1989 have been issued by the Election Commission in exercise of its power vested in it under Section 29A of the Act, which clearly does not empower the Election Commission either to declare a political party as a national party or to reserve its election symbol. Therefore, paragraph 3 of the said letters of registration are bad in law. Stop.